everyone, and welcome to the Weekend Up to You, brought to you by JELS Corporation. Today's update will cover employment and corporation law. Let's start with a work-related injuries case. Let's welcome our correspondent, Leah.
Hi everyone, I'm Leah, and today we're here to talk about a very interesting workers' compensation case. This case is called the Choctaw Resort Development Enterprise versus Applequist. In 2014, in the state of Mississippi, a very interesting case was brought up to the appellate court. This very unusual circumstances brought it up to the appellate court, and it was eventually heard on June 11th of 2014. The situation begins when Virginia Applequist was returning home from work late one night at 4 a.m. and she was in the car with her sister. Her sister was driving when a 400-pound hog jumped out in front of the car, resulting in various injuries for both of the sisters. They both were hospitalized for several days, but this was not the end of the recoveries that Applequist wanted to receive. She filed a workers' compensation suit against her company, and she wore a back brace for several days, but she did not receive any workers' compensation. Therefore, this was brought up to the appellate court. The main key that allowed Applequist to eventually win this case was the fact that she was working, quote unquote, when she was struck by the 400-pound hog that resulted in all of her injuries. Although it is very unusual, it is still regarded that she was working because she was following her duties as a executive host for the casino. Her duties as the executive host was to be able to organize all of the benefits and the cost of her working at the casino, and also look at the competing casinos, which she was doing when she was returning at 4 a.m. She said that her sister knew that the roads better, and she did not, so because she had recently taken a pain reliever, and she was also not knowledgeable about the roads back there, so that's why her sister was driving. Because she was on her way back from performing her work duty, that makes the company liable for all of the damages. So unusual as this case seems, it definitely was resolved in the correct manner because Applequist eventually received her workers' compensation and won her case.
So how will this case affect companies in the future?
Well, in general, when a worker is on duty, their company is liable for the protection, and they should be held responsible in any case of work-related injuries. So this was resolved correctly.
That's definitely a good thing that she won her compensation case. Moving to a very current discrimination lawsuit, Lowe's, the hardware store, settled for $8.6 million after being sued by the EEOC in a disabilities discrimination case. Lowe's was being sued for engaging in a pattern and practice of discrimination against people with disabilities by firing them and failing to provide reasonable accommodations to them with their medical leaves of absences because they exceeded Lowe's 180 days maximum leave policy. The EEOC stated that the company violated ADA policies by terminating individuals who were regarded as disabled, had recorded a disability, and or were associated with someone with a disability. Lowe's decided to settle the case for $8.6 million and also agreed to have an ADA consultant to review and revise company policies. Additionally, they will need to implement effective training for both supervisors and staff on the ADA policies. The company has agreed to develop a centralized tracking system for employee accommodations and provide regular reports to the EEOC verifying compliance with all the decisions.
Speaking of business decisions, Amazon may have just avoided a messy employment discrimination suit. For the past few years, the e-retail monolith has been developing an AI resume scanner. How it worked? The machine was supposed to scan resumes for potential hires. The system was programmed to pick up on keywords based on what recruiters were looking for, such as work experience, internships, things like that. Jeff Bezos, the company's CEO and head of this particular effort, instructed employees to feed the machine with tens of thousands of past resumes to test how it worked. And what they discovered was surprising. Female applicants, or at least those applications which contained more flowery adjectives, were overwhelmingly rejected in favor of that of men's. If you're curious, descriptors like executed and captured correlated much more to male applications, which the system then learned to reward. The official explanation for this pattern was that because the technology industry is so male-dominated, female applications started being viewed as anomalies or built-in errors. Even after trying multiple times to reroute the system's software and remove its clear gender bias, Amazon eventually put a stop to the project in 2017 to avoid what would have been sure to eventually blow up in their faces.
And Amazon already has its fair share of controversial policies. In fact, they've recently made a monumental business decision that got a lot of people talking. Julia?
Right, so AI isn't the only industry that Amazon's been experimenting with. In one of the biggest company acquisitions of the decade, Amazon bought Whole Foods. Jeff Bezos reportedly paid over $13 billion for the opportunity to take advantage of the huge demographic overlap that exists between both companies. The move demonstrates Bezos' intentions to keep building his, quote, Amazon ecosystem and to lead the way into rethinking the grocery industry, which has remained unchanged for decades. While the grocery conglomerate wasn't forced to rebrand or restructure its corporate organization, its buyout did spark lots of controversy.
What kind of controversy are we talking about?
So there have mainly been concerns about to what extent Amazon can grow before being considered as a real monopoly by the federal government. And if it ever were to be considered as one, how would the government even address the issue? Would it have to divide and distribute parts of the company to private owners? With all the cross-industry success that technology companies have been enjoying as of late, these are both questions that aren't going to go away anytime soon.
Got it. Thank you. We'll now move on to our next case, which also pertains to a questionable corporate organization. Leah?
A very interesting corporate law case was brought forth in the Supreme Court, and it was titled the AT&T versus the People. In a 5-4 majority, it was ruled that class action lawsuits were prohibited against this major corporation. This allows AT&T to establish an even stronger monopoly on the market and takes away the consumer's power when they want or have a complaint. This made the judges greatly call into question the ideas of consumers' rights with also the balance of normal litigation. When one consumer wants to file a lawsuit against a company for overcharging them or lying on an ad, they have no power just themselves. But lawyers are able to utilize class action lawsuits to increase the consumer's power in the courtroom. However, with that extreme consumer power at that point, that puts the corporation at disadvantage. So this decision reversed the power roles, and it provided AT&T with a new source of protection while upholding their power in the monopoly.
Switching gears to something for all of our soccer fans, we have a story that pertains to not only female players, but also those who support the sport and its future. Ellie?
This last month, the U.S. women's national soccer team filed a lawsuit against their governing body, the U.S. Soccer Federation, suing for gender pay discrimination. That's right, the women's national team, who have won multiple World Cups and Olympic gold medals in far less time, are paid exponentially less than the men's national team, who have no real titles to their name. The women are currently ranked number 1 in the world, the men number 34. That seems fair. 28 members of the team form the class of women, arguing that the Federation not only discriminates against them in terms of salary, but also in training locations, medical treatment, coaching, and other benefits. The class action suit focuses on U.S. soccer's blatant violation of the Equal Pay Act of 1963 by fostering a clear gap in pay by means of sex, and clearly not by merit. ESPN conducted a study by comparing the salaries of the women's and men's national teams respectively if they both hypothetically played and won 20 friendlies. The maximum earnings a women's national team member could make was $99,000. The average earnings a men's national team member would make was $263,320. This illustrates how on average the men's team will make 2 to 3 times as much as the women, and they didn't even qualify for the last World Cup. Alex Morgan, co-captain of the women's national team and one of the plaintiffs in the suit, commented on the situation, saying, "Each of us is extremely proud to wear the United States jersey, and we also take seriously the responsibility that comes with that. We believe that fighting for gender equality in sports is part of that responsibility. As players, we deserve to be paid equally for our work, regardless of our gender." The suit is expected to be heard in court in coming months, even with the upcoming Women's World Cup beginning in Paris in early June on the horizon.
We want to leave you guys with a bit of brighter news. Here's Julia with our closing piece.
So obviously, we've heard a lot today about how deeply cases involving employment or corporate law can affect individuals. And that goes doubly for those that are really physically affected by what happens at work because of it, as Virginia Applequist and her sister can attest to. However, it seems as though the seriousness of these situations hasn't quite sunk in for everyone. In 2014, Lucy Bauermeister and her friend Anna Ramatowska filed a suit for physical damage caused by a gas explosion that took place several blocks away from them. Even though the women's legal briefs claimed that they had suffered mental and physical scarring due to the blast, they were recorded numerous times claiming to have gotten only like 5 or 6 scratches. Apparently, this justified their suing the gas company for $20 million each. And surprisingly, the case actually ended up making it to the Bronx Supreme Court. The women's lawyers tried using bystander and direct theory, and the gas company failure of direct duty to make the case. Eventually, however, it was dismissed.
At least there's that. Thank you, Julia. That concludes our JELS Weekend Update. We hope you've enjoyed it and have a great week.